Okay, welcome everyone to our second installment of the 4 modules that we're going to cover on the online training for legal practitioners and CSOs on engagement with the African Court and the African Commission on Human and People's Rights. This is an online training convened by the African Court Coalition in partnership with the Raoul Wallenberg Institute on Human Rights and Humanitarian Law. As I said, this is our second module. Today on the 8th of October, the first one was on the 1st of October, where we looked at rules of procedure for the African Court, as well as rules of procedure for the African Commission on Human and People's Rights. And we learned that both institutions have devised their rules. But what is important from module 1 is to say that engaging with the rules of these two bodies is part and parcel of engagement, which is the main objective of this online training. Allow me to quickly reinstate or to restate the objectives of the training. The first one being to enhance the knowledge and capacity of legal practitioners in order to enable them to effectively and strategically engage the African Court and the African Commission. Secondly, is to increase awareness and understanding of the available implementation mechanisms and effective ways to follow up and influence implementation of decisions of the African Court and the African Commission. So I'm excited today because the module speaks directly to the issue of strategic engagement. I think many of us have, in one way or the other, engaged the African Court or engaged the African Commission. So anyone can engage these institutions. But what we are focusing on in this training is strategic engagement, is engaging these institutions with a strategy, with a method, and anticipating an outcome of that engagement. So it's not ordinary engagement, it's strategic engagement. So the presenters today are going to take us through their thoughts on what amounts to strategic engagement with the African Court and the African Commission, but also to learn from our friends from the other regional system, the Indo-American system of human rights. We're going to learn a lot of things to see how they've also been engaging with their own human rights bodies in that system. And I remember clearly from module 1, someone raised a question to say, how does the African system engage or draw inspiration or share ideas with other regional systems? And today is an opportunity for us to share, to draw inspiration or share what we do in Africa, in the African system, but at the same time also to draw inspiration from the Indo-American system of human rights in terms of strategic engagement of human rights bodies in these two systems. I will not take much time further. I would like to introduce our first presenter today. And our presenter will be looking at strategic engagement with the African Court and the African Commission on Human and People's Rights. And then in the second session later on, we'll then be looking at the lessons from the Indo-American human rights system on strategic engagement with the Indo-American Court and the Indo-American Commission. You can see we're already talking about a court in Africa and a commission in Africa, also a court in the Indo-American system and a commission there. So really, I'm looking forward to this conversation today. So our first presenter is Ms. Evelyn Chijarira, who is currently the program manager at the Pan-African Lawyers Union, otherwise known as PALU. She is an African human rights activist with a passion for issues surrounding human rights, governance, the rule of law, and democracy. I already said she's a program manager with PALU, and she is the focal point of all human rights and litigation issues at PALU. She studied at the University of South Wales and holds an LLB degree from the University of Sheffield and a postgrad diploma in facilitating organization, learning and development, and is also a part of the Makwanyane Death Penalty Training Institute alumni. She has over 10 years experience working in the field of human rights, on human rights issues, conducting consultancies and partnerships with a range of organizations, including the United Nations, International Criminal Tribunal for Rwanda, ICTR, the Salama Fikria Kenya, British Foreign and Commonwealth Office, the Law Society of England and Wales, of course, the Makwanyane Institute and the Cornell University, to name a few. She litigates before the African Court on Human and People's Rights and actively advocates for the use of regional and continental redress mechanisms that include, but not limited to, the African Court, the East African Court of Justice, the African Commission, and the ECOWAS Court of Justice in West Africa. So I think, colleagues, you agree with me that we have a colleague among us who can take us through her thoughts on how we can strategically engage our African human rights bodies, the African Committee, Court on Human and People's Rights, as well as the African Commission on Human and People's Rights. So as she goes through a presentation, we'll allow you time to present for the next, to talk for the next 30 minutes with no interruption. And at the end of the presentation, we will allow her to, allow the participants rather, to raise questions with her. A few verbal questions and comments will be allowed through the platform, but I expect to receive more comments and questions through the chat box. And we'll put those questions to the speaker at the end so that she can answer questions and react to some of the comments that we are going to raise. Without any further ado, let me call upon Evelyn to take us through a presentation. Evelyn, you have the floor.
Thank you, Tarisai. Can you all hear me?
Yes, we can.
Yes.
Perfect.
Yes.
So I'll be sharing my screen to make it easier for the participants to follow. I'll also try and speak slowly. I tend to speak fast. So if I speak fast, moderator, please interrupt me and tell me to slow down.
I will.
Thank you. The introductions have been done already. So how I'll approach this, I'll speak briefly about what strategic engagement is. And then I'll talk about how, from our own experience at PALU, I have utilized strategic engagement with the African Court and the Commission, so at least the litigants can get an idea of how to engage them. So just to start, what is strategic engagement? I think the moderator introduced that a little bit. In the literal sense, it is the best form of doing whatever action you take in order to maximize your chances of success. There's no right or wrong answer to strategic engagement. It's just basically what you do, how you do it, when you do it, and why you do it. Two common forms of strategic engagement that the Pan-African Lawyers Union has used in the past. strategic litigation and advocacy. So I'll speak about both, hopefully time allowing, for both the African Court and Commission. Strategic litigation, what is it? Firstly, we have to distinguish this from the traditional form of litigation, in that rather than focusing on just the judicial decision itself and immediate redress for the named plaintiff stroke claimant, the litigation in strategic litigation is actually part of a broader plan that includes issues of political and social techniques, but also with a goal of achieving broader change. Such litigation has often been used to achieve social reform and benefit disadvantaged social groups through access to justice. It has been used to advocate for human rights protection, especially in situations where states, individuals, companies, to name a few, are falling short. The main intention of such litigation is to bring about, as I mentioned before, a positive broad impact on the law, on policy development, as well as setting precedent for outcomes in future similar cases. So first, I'll look at the objectives of strategic litigation. As I mentioned, to bring social reform, increase access to justice, raise public awareness on an issue, increase accountability while fighting impunity, where people are falling short of their responsibilities, and to strengthen the rule of law. I'll look at the advantages before I go to disadvantages. The advantages, you get legally binding decisions, some groundbreaking, norm setting and trend setting. In our strategic litigation with before the African Court, we've gotten some amazing groundbreaking decisions on the right to legal assistance, for example, freedom of expression and association, to name a few. It also raises visibility on important issues, especially issues of gross violations of human rights, though not limited to those. But it's an important, effective way of fighting impunity by raising awareness and bringing attention to these issues. And in some cases, where reparations are awarded to the claimants with costs imposed on perpetrators, it's also a form of redress and reparation and sort of covering up for what has happened. And also in litigating strategically, it's also a form of documentation and data gathering. The disadvantages: it can be expensive, especially if you don't have sufficient funds. But also, as I mentioned, there's an advantage that costs can be meted on the person, on the respondent. The same can be done to the claimant. Sometimes the court may rule against you and costs end up being meted on you. So it can be expensive in that way. And at times, it's also time consuming. We filed some cases that have taken 2 to 3 years before we got a judgment. So not everybody's willing to wait that long. And with regard to international courts and tribunals, it relies heavily on ratifications of international instruments. Obviously, this is different at national level, whereby they rely on just their constitutions and national laws. But also the adversarial nature of this type of litigation, in that in most cases, before regional or continental mechanisms, you have the applicant, stroke client, against the state. And this can lead to a risk of backlash. We have filed a number of cases, actually, where we ended up with people that had to go into exile after reprisals by their governments. And it was not a very pleasant situation. These are people with families, a livelihood, They're forced to drop everything and then they just leave everything. We managed to get funding for some of them, but obviously this funding in terms of sustainability, it's always an issue, excuse me. But the commission, under the new rules, as you can, under Rule 107, it speaks of protection of people that may be at a risk of reprisals. But obviously, I don't know how sustainable it is and how many people it is, but if somebody has to leave their home, it's not exactly the best outcome you'd be looking for. And there's also the risk of non-implementation. Sometimes you get the most amazing ground setting, norm setting judgments, but there's just no implementation. I'll speak briefly about implementation when I speak about the stages of strategic litigation. But I'm not going to go too much into it because there's a webinar that the African Court Coalition is organizing that's going to focus specifically on implementation. So please, when they send the details, register for it. Before I go into the stages of strategic litigation, I would like to give you a hypothetical case study. And as I go through the different stages and what it is you'll consider when you're engaging the courts through strategic litigation. There's a gentleman called Mambo who resides in the state of Zingo. He was arrested and tried for armed robbery. Despite the trial being marred with numerous inconsistencies, he was convicted nevertheless and sentenced to 50 years in imprisonment. Mambo has been trying to appeal for the past 20 years, but needs the record of proceedings from the first instance courts. But all efforts so far have proven fruitless. He's written to the various offices, tried everything, and nothing has worked. So we have NGOX that hear about Mambo, and they'd like to help. So they've sent in some lawyers to meet with him and to discuss. So as I go through the phases of strategic litigation, I'll just call it SL in short. It's a bit mouthy and a bit of a tongue twister. I'd like you to think of Mambo's situation in terms of stages 1, 2, and 3 that I've listed here. So in strategic litigation, always start with the stage 1 of case development and investigation. This is followed by hearings, which could be the trial, deliberation, up to the ruling or judgment. And then what actually happens after judgment has been passed. The first stage, case development. If you're going to engage in SL, you need to start from this point. This is the point in time where you do your client and cause selection. Sometimes this is based on the mandate that you have as an organization. At the Pan-African Lawyers Union, one of our main focuses is the promotion and protection of human rights. So the majority of our cases so far have been on human rights. So that could be the reason. And at the case development level, you also discuss with your potential client of whether they actually want to file a case. We've had situations of people going to file cases before the African Court or Commission, and the clients actually do not want that type of attention. The second issue would be, does your client want to file under his name, or they prefer to do it anonymously, or they prefer to do it through an NGO, CSO, or other organization? It is also at this stage you do the evidence collection, but it's important to note that it is not always possible to get that evidence. It is also the stage you do a cost analysis, and also the stage that you do a risk analysis, because there's a chance of possible backlash, issues of client safety, and also issues of you as counsel representing the client, or as the NGO that's going to file in its name, also issues of your safety. So you need to do a risk analysis and see what mitigating factors you can come up with. It is also at this stage that you choose the forum that you're going to use when you're strategically litigating. In this case, for today's discussions, I will limit myself to the African Court and the Commission. But obviously there are other means of redress, which are also regional, international, that you might want to access. But it's at this particular stage that you start asking these questions. And one thing to keep in mind while you're at this stage is that there are many, many cases that are dismissed on admissibility at admissibility stage. And the unfortunate part is sometimes when you look at it, they're actually proper grounds whereby if it had gone to be decided on the merits, it would have been successful. But just a little bit of research right in the beginning at case development stage would have helped to alleviate some of these problems and avoid being dismissed on admissibility at admissibility stage. So I'll start with the African Court. I'm still at the case development stage. The question you start asking, who can file a case? So if we have Mambo, the case study I gave you, and he wants to file a case, we start off with there. Who can file? The African Commission can file a case at the African Court, but also the African Commission and the court have a complementarity agreement in that the Commission can refer cases to the African Court and vice versa. And they're secondly, state parties to the protocol establishing the African Court. African intergovernmental organizations, and you also have individuals and NGOs, but this is against states that have made the Article 34.6 declaration, which allows individuals and NGOs to take cases to the African Court. How do you file the case as well? This can be hand-delivered to the African Court. We even had one case where somebody filed a handwritten document in the past. I'm not sure if this still continues under the new rules, to be honest, but you can hand deliver it. You can post it, email, fax, or courier to the registrar at the African Court. And this is governed by rules 27, 31, 39 1D, 40 and 41 of the new rules of the African Court. You can file your case in Arabic, English, French, Portuguese, Spanish, Kiswahili, which are the official languages of the court, but also any other African language is acceptable. After you move from there, another important issue to consider is the issue of jurisdiction. What jurisdiction does the African Court have? This is important because you do not also want to file a case that is outside the African Court's jurisdiction, and it ends up being thrown out on that small technicality. So the African Court and the Commission, I'll mention both now to save my time, I'm almost at 15 minutes. They both have contentious and advisory jurisdiction. On contentious jurisdiction, what is this? This is basically a case where human rights violations are alleged. You approach the court and you ask them to interpret and apply the African Charter, the court protocol, and any other relevant human rights instrument that has been ratified by the state or states concerned. It also has advisory jurisdiction. This is the situation whereby you ask the court to provide an opinion on any legal matter relating to the African Charter or any other relevant human rights instrument. Just caution to be taken with advisory opinions. The court is always cautious, especially because sometimes some individuals or organizations try and go through the advisory opinion route when it's actually they're trying to litigate a contentious matter but hiding under the advisory opinion. So phrasing is important. If you're asking the court for a legal opinion, it needs to be clear that it's an advisory opinion, not that the lines are blurred and it's not very clear, because it can get dismissed. Another important issue is that both the African Court and the African Commission are not part of an appeal system in the ordinary sense of the national court systems. There was a really good case against Malawi, which was filed at the African Court, but the applicant made the mistake of writing that he was appealing a national court decision. So there's a difference between you are appealing to the African Court and appealing a national court decision. So that's always important in strategic litigation. Phrasing is important. You need to phrase it properly so it does not appear like you're seeking jurisdiction that the court does not have. Another important issue is the state you're complaining about. Has it ratified the protocol establishing the African Court? There was a case, the Amir versus Republic of Sudan. It's been a while, but it was dismissed on admissibility because Sudan had not ratified the protocol establishing the African Court. Something that's also important is for individuals and NGOs. Has the state made the Article 34.6 declaration? A complaint against a state which has not made the Article 34.6 declaration, that is filed by an individual, an NGO, or NGO will be struck out. At the moment, it's only Burkina Faso, Gambia, Ghana, Malawi, Mali, and Tunisia that have made the Article 34.6 declaration. Unfortunately, Tanzania, Rwanda, Cote d'Ivoire, and Benin have withdrawn their declarations. One thing to note, though, is that it's still possible, even for these countries that have withdrawn the declaration, or other citizens, as long as the state has made the protocol, to file a communication through the African Commission and explicitly request that it be transferred to the African Court, it be referred. At times, the Commission does this at its own initiative, but sometimes you can actually explicitly request. So for countries like Tanzania, for example, whereby made the withdrawal in November last year, it's taking effect in November this year. After that, you can still file a case against Tanzania through the Commission, and then you ask the Commission to refer it to the African Court. Obviously, this also depends on, if it's somebody who's indigent, incarcerated somewhere, their financial capabilities of now couriering it to the Commission. It's a drawback, but it's not entirely like a dead situation. Another issue to consider is also whether the NGO or CSO has observer status with the African Commission. This is essential because without this, the case will also be struck out. Issues to consider on admissibility are stated under Article 56 of the African Charter. I will not go into these right now. I'll maybe speak about just the issue of filing after exhaustion of local remedies within a reasonable time. That requirement is there in the Charter, that you should file before the African Court within a reasonable time after you've seized the highest court of the country you're suing. But it's important to note that the African Court has clearly stated in its judgments that cases will be dealt with on a case-by-case basis, one. And secondly, they will look at the situation of each individual applicant to see where he is. Did he have legal representation at national level? Is he indigent, incarcerated, and all those? We even had a case that was filed by somebody who'd been waiting, I think 5 years, but because he was incarcerated and indigent, it was ruled admissible. And another issue to also keep in mind is that in terms of exhaustion of local remedies, they have to be available, effective, and not unduly prolonged. So it will be on a case-by-case basis. Besides filing a case, an application before the African Court, You can also, even if you don't go that way, if there's a case you're interested in or a cause you're interested in, you can also file an application to be admitted as amicus curiae. This is another very important form of engagement. It's provided for under Rule 71 and Practice Directions 42 to 47. At PALU, one of our most memorable contributions was when we appeared as amici in the case of Issa Konate against Burkina Faso. It was a freedom of expression case, and we made interventions on issues of proportionality, permissible restrictions, and the importance of freedom of speech in a democratic society. So even if sometimes you cannot be the applicant or litigant for one reason or another, and there is a cause you're interested in, this is one possible way. Another one, you may find the case is already ongoing, but you have an interest in it. Under Rule 61, the court may allow state parties or any other person with an interest leave to intervene and actually make submissions. I'm running out of time, but those are the key stages of the litigation process at the African Court. It's important to note that there's also the option of amicable settlement. Some litigants don't like this one because you may go and sign and agree on something, but you go back home and the state turns on you. But it's also important to note that this is only in contentious cases. And it's also important to note that the court can at any stage issue provisional measures. This can be at the request of the litigant or litigants, or they can act suo motu and do it on their own initiative. But it's pretty straightforward, and also the new rules have all the stages in the litigation process. So you can always download them from the court's website and go through them. After your judgment has been given, has been delivered, judgment stroke ruling, you should also consider you can request for interpretation. This is under Rule 77. So this also helps for the purpose of executing the judgment. It can be time consuming. We've had cases that the respondent requested an interpretation, and it ended up taking over 2 years to get a ruling. So delaying everything. But at the time, I think everybody had sort of interpreted the rules to mean that there's a stay of execution, the respondent anyway, while they're waiting for the interpretation. But the new rules are clear. You have to do it within 12 months, but it will not stay execution. But I think there also comes the question that how do you execute something you're not really understanding? So maybe it's an oversight, but it's also something to consider. There's also a request for review under Rule 78. This is when a new fact or evidence has come up after the judgment has been delivered. This has to be within 6 months. It's usually done by the applicant. But the court can also, on its own initiative, review its own judgment under Rule 29(2)(c). Another important stage is implementation. Very controversial and hot topic right now. I think webinar 4 is on this, so I will not go too much into it, but it has been an issue. We've had at PALU, some amazing, amazing judgments, but they've just not been implemented. We've gone to speak to the court, and they explained that it's the Executive Council that's in charge of this, but that they were amending their rules to also make sure they follow up more. And with the new rules, we can see Rule 81 provides for a procedure of implementation, unlike before. It also provides for hearings on implementation. So hopefully this is more successful. But this is also a useful way to engage the court once you get your judgment. I'm running out of time. Challenges the court faces. These are challenges to also consider when you're litigating. Limited knowledge of the African Court rules of procedure by complainants. As I mentioned before, this is what's leading to so many cases being dismissed on admissibility. Another issue is lack of awareness of the court. People just do not know about the African court. I have met people that live in Arusha that have lived here, but when you mention the African court, they've just not heard of it. There's also the issue of limited number of ratifications and declarations that are made under Article 34.6. And now more recently, it's also the withdrawal of Article 34.6. This could be due to lack of political will, or just fear of states being brought to justice, or the court gives a judgment the states do not like, and they say, well, you know what, we'll just withdraw, take away the access. And this is where it's important to realize and to know the rules of the court and how the court and the commission also have that complementarity, and how even without the 34.6, you can still file the cases. I will quickly go through the African Commission. A lot of issues overlap between the Commission and the African Court. I've mentioned the jurisdiction, so I will not take much time. And the African Court Coalition is going to share all the presentations. So I have like 3 minutes to go. Who can bring cases? The same as the African Court: individuals, CSOs, NGOs, state parties. And there's also a provision for anonymity when you are filing a communication before the African Commission. If you don't want your name to be out there for safety reasons, you just explain in your application and clearly state the reasons why. So you'd find your case being B versus this country, or A or X, for your protection. And one thing to note as well, for both the African Court and the Commission, I'm almost out of time, it's that they will not admit a case that has already been settled by another redress mechanism on principles of the African Charter, the same vice versa. And also even the court or the commission will not consider a case that is being considered on the same issues by either the African Court or the commission. This will be shared, so I'll move quickly. They also have amicus interventions. You can apply to be an intervener. There are key stages in the litigation process. They also have literally like a specific decision on admissibility. So it's very important to get the admissibility aspect correct. They also issue provisional measures, but out of time, so let me go quickly. These will be shared.
Yes,
so,
Evelyn, sorry to interrupt. Yes, I will give you another 5 to 6 minutes to add to the little seconds, the few seconds that you're left with, so that you don't, rush too much. Make sure that you exhaust the issues that you think participants need to know. Thank you.
Thank you, Tarisai. Just some important things to note about strategic litigation. This is more than just winning a case in a court of law. This is more about, it's doing what you're doing best, but it's also about winning, not just in the court, but also public opinion. Once you raise the awareness, people are aware of the situation, you've drawn attention of the public to a particular matter or issues, and you bring about change. These can even be small steps, or they can be big steps, but the important aspect is raising the awareness. So as you're trying to see how you can strategically engage the African court, those are things to also think about when it comes to litigation, strategic litigation. So on the one hand, I have spoken about strategic engagement through strategic litigation. But on the other hand, there's also another way you can strategically engage both the African Court and the Commission, and this is through advocacy. This is just basically, in short, the active support of an issue or a cause. It can happen before, throughout, or after proceedings. And what you do is you're giving a voice to all, including the vulnerable. This you can do through press releases and use of social media, Twitter, Facebook, blogs, newspapers. Nowadays, things are different. You know, when you look 15, 20 years back, somebody would be arrested. And by the time the information would come out, it would be forever. Nowadays, as you're being arrested, somebody can even record it. It's tweeted everywhere. That's one form of advocacy. And before long, it's everywhere. And we found advocacy very useful. There's a case, we had a gentleman who'd been arrested for treason and charged with a long string of sedition crimes. We did our advocacy, did our press releases and everything. And before long, he was pardoned. He didn't have a very good ending in the end, but at least we could see where that advocacy went and where it contributed to. And even like with the African Commission, they have their public sessions, which they invite CSOs and NGOs. You can make statements there. You can connect with commissioners of a working group you're interested in, get them to speak on your behalf. Commissioners also send letters or not verbals to states on particular issues. And they also bring attention to violations. And we also have the litigants group. We have the Coalition for an Effective African Commission. We have the NGO Forum, and they're all working together by having sessions, by having press releases, steering committees that are working together to work in enhancing the work of the African Commission. And this is a way that you can also strategically engage the African Commission. So it's not strictly limited to just litigation. When you look at advocacy, you need a strategy. And in order to effectively carry out what you're doing. One thing to keep in mind is it's a contact sport. You need to be actively in it. Start small, aim big. It's also good to do an analysis of your allies and components. Forge alliances with your allies. And you can also do like a scoping exercise, see what is there, what is being done. So instead of duplicating efforts, you engage existing CSOs and coalitions and movements, whether they're national, regional, international. See how they're engaging the African Court and the Commission, how you can work towards that. If they're a membership forum, can you join that forum? How you can work with them to bring about change. Where possible, at PALU, we use a lot of press releases. As I mentioned before, that's very useful. There's always the sub judice rule, but just be conscious, it shouldn't constrain you to the point that you cannot communicate. Also, encourage amici career applications, interventions as interested parties in cases. So if for one reason or another, you cannot be an applicant or complainant, you can still do an application and be admitted as an amicus or an intervener. And I think through your media forums, encourage mass court attendance, encourage as much information dissemination as possible when it comes to the work of the African Court and the Commission. Moving forward, I'll just close by telling you that first thing, instruments do not ratify themselves. Please inquire to the best of your knowledge what ratification campaigns have been undertaken in your country or region, which can you join, how can you contribute, which ones, in addition to the ones you've participated in, if any. But instruments will not ratify themselves. An example is the Convention Against Torture. It is one of the list, it's not very much ratified. Even in Tanzania, it hasn't been ratified. But see how you can contribute to that. What has been done, which movements are there. Another thing to consider and to keep in mind, judges and commissioners do not elect themselves. All the information is on the internet. If you go to especially the African Commission website or even the African Court website, we even as PALU always disseminate information when it comes to nomination of judges. The African Court Coalition does the same. Look at the process. It was actually, we had an unfortunate situation a few years back. The African Court was nominating judges, and we sent letters to all the national bar associations in Africa. asking them to be involved, to look into the process. And out of it, all of them, only South Africa responded. This was quite disappointing, especially when we attend meetings and we see people complaining furiously about the fact that we don't know how these judges are nominated, or we don't like the judges, and they're questioning issues of the judges' impartiality and all that, and how representative the bench is. But you can do some advocacy work around this, and it's an effective way of strategically engaging the court. And the court has an open door policy as well, even the commission. You can schedule an appointment. Well, before the COVID situation, you could always go. We are based in Arusha, so we have visited the court on numerous occasions. We've met the registrar, we've met the staff. When we have concerns, we raise them. That's the way of strategically engaging as well. So it's not just tied to the litigation aspect or this advocacy of posting, but face-to-face, virtual, emails. It's a way of engaging them as well. Another thing to note, decisions do not implement themselves. I know it's an area I said I'm not going to focus much on during this webinar. There's going to be one dedicated to this, but see what you can do. Look at the processes, engage the court, engage the commission, ask them about their follow-up. How do they follow up on implementation? How can you help? With the new rules, for example, at the African court, they are now holding hearings. You see a judgment is delivered or ruling given today. The respondent is given 6 months to implement. Follow up. What has been done within the 6 months? What can you do until then? Can you engage the government of the state concerned? What can you do? I think that's why I said it's a contact sport. It's more about just sitting down in meetings and complaining bitterly about the African court or the commission not implementing decisions, but also what are we doing? And finally, I think do the best you can when it comes to strategic litigation. Are you a registered pro bono lawyer? Even in your respective states. And also the African court, for example, has a list of legal aid counsel. You can sign up for it, look at the recommendation, the requirements, what is required for you to join this and to be admitted as a legal aid counsel. What can you do? And also, finally, I encourage you to join PALU. We're a membership organization for individual, national, regional bar associations. So join us and be active in our committees. We have even a litigation committee. We have a committee for the African Commission. So you can see, and through these, we can talk and see and brainstorm and engage on how we can strategically engage them beyond even just the litigation or the advocacy. What else can you do? So thank you. I've gone almost 10 minutes over my time, so thank you for the extra time.
Thank you, Evelyn, for an elaboration of issues. Like I said at the beginning, that there are different forms of engagement or engaging the African Court and the African Commission. But what we are looking for, or what we are focusing on in this particular training, is strategic engagement. And that's exactly what Evelyn has been talking to us about, how to strategically engage the African Court, how to strategically engage the African Commission, as well as the issues to do the advocacy, to say litigation alone, even if it's strategic, litigation alone is not enough. You might go to court, you might get your decision in your favor, but nevertheless, you need advocacy to support the litigation by raising the issues during the trial, during the consideration of the issues or of the lawsuit or of the case. And more importantly, probably at the time of implementation of that decision by the state part concerned, you need a lot of advocacy to bring the issues to different stakeholders, to pressurize state parties to fully implement decisions and recommendations of our human rights bodies. So she was focusing on that strategy, do it strategically. Anyone can do advocacy. Anyone can do litigation. But are we doing it strategically? Are we engaging these institutions strategically through litigation and through advocacy? And as Evelyn has said, the slides would be shared with all participants through email to ensure that we don't miss anything from that wonderful presentation. And I am looking in the chat box to see whether there are any questions that have been posed. But as I go through that, I'll give a chance to those who are raising their hands. I see 2 hands. The first hand is Tomo and then Caroline. So right now, I will allow Tomo to make their contribution. Just a moment. Tomo, can you make your contribution, please? Tomo? The IT, please can you assist Tomo to make their contribution?
He's muted on his end.
I beg your pardon?
Tomo is muted on his end.
Tomo is muted?
Yes, on his end.
On his end?
Yes.
Okay. Let me move on to Caroline then. Oh, Tomo is muted now. Tomo, can you make a contribution, please?
Oui, bonjour. Vous m'entendez?
Yes, we can hear him.
Vous m'entendez très bien? Bon, merci. Merci. J'ai quelques petits commentaires à faire par rapport à la présentation de Madame Evelyne. D'abord, je la félicite pour sa communication. Mais je me suis rendu compte que dans sa communication, elle a dit que même au niveau de Arusha, en Tanzanie, la Cour est méconnue de la population tanzanienne. Alors, je me dis, si déjà à Arusha, en Tanzanie, la Cour n'est pas connue, mais à plus forte raison, les autres pays d'Afrique. Donc, il se pose le problème de dissémination du travail de la Cour. Alors, ma question est de savoir quelle est la stratégie de communication au sein de la Cour africaine des droits de l'homme et des peuples qui permet de faire le marketing de la Cour africaine en Afrique. Ma deuxième question, parce que la dernière fois, je n'ai pas eu l'occasion d'intervenir, ma deuxième question, le nouveau règlement intérieur de la Cour auquel vous faites allusion à l'engagement stratégique aujourd'hui, est-ce que ce règlement intérieur de la Cour a tenu compte du protocole de Maputo de 2014 qui est en train d'amener la Cour vers une Cour des droits de l'homme et de justice? Enfin, c'est deux petites questions. La première petite question, c'est une sous-question. Vous parlez souvent de l'épuisement des voies de recours internes, l'épuisement des remèdes internes avant de saisir la Cour. Alors, je me pose la question. Vous m'entendez?
Yes, we can hear you.
Vous m'entendez? Si vous m'entendez bien, c'est bien. très bien, je suis vraiment ravi. On parle de l'épuisement des voies de recours internes avant la saisine de la Cour. Je ne sais pas si dans les réflexions, il y a un référé d'urgence. L'urgence pour commander à ce que la Cour prenne des mesures qui sont commandées par l'urgence. Alors pourquoi toujours attendre à ce qui est épuisement des voies de recours internes? Et dans le même ordre d'idée, nous savons que les droits de l'homme sont universels. Et en matière pénale, par exemple, il y a le principe de l'universalité, de compétence, la compétence universelle. Pourquoi ne pas introduire au niveau de la Cour africaine des droits de l'homme et des peuples l'universalisme qui permet à la Cour de mettre un pas à l'écart la question de la ratification des protocoles reconnaissant la compétence de la Cour. C'est là le problème. C'est là le problème. Quand on dit qu'il faut d'abord faire la déclaration de compétence, il y a certains États qui ne le font pas. Pourquoi ne pas envisager l'universalisme de compétence de la Cour à l'image de la compétence universelle? Et pour terminer, je me suis rendu compte qu'il existe un serveur au niveau de la Cour africaine des droits de l'homme et des peuples. Quand il y a des candidatures aux postes qui sont lancées, il y a des candidats qui se manifestent et qui déposent leur candidature. Malheureusement, je me rends compte qu'il n'y a jamais de réponse aux candidatures qui sont manifestées. Au point qu'il y a parfois des découragements quand il y a des postes ou bien il y a des candidatures qui sont lancées. Les gens sont découragés parce qu'il n'y a pas de réponse. Est-ce que cela ne peut-il pas jouer sur l'engagement stratégique dont vous faites état en faveur de la Cour et en faveur de la Commission? J'espère que je n'ai pas été très long. Je vous remercie.
Thank you. Thank you. I recognize Caroline. Please make your contribution, Caroline.
Hello, can you get me?
Yes, we can hear you. Please go ahead.
Okay. Yeah, I want to thank the presenter because he has some sort of lightened my burden as I came in for these classes with a heavy heart, and I was a bit confused as to what I was going to do because I had already given up on the African Commission and the African Court. I have my first question pertains to my country, Cameroon. In 2003, there was a complaint against the state of Cameroon, a communication against the state of Cameroon before the African Commission. And the decision came out in 2009. Up till date, the state of Cameroon has not complied. What can be done in this situation, especially following the fact that some of those who were complainants in the communication are now imprisoned and they have been sentenced to life imprisonment? That is my first question. And then the second one is concerning Palu. I wish to know how Palu decides on, how Palu selects cases to do advocacy. How they do their selection to get cases to do their advocacy. And if Palu has been doing anything on the ongoing genocide in Cameroon. And my last question is on the disadvantages of commencing an action in the court of, in the African court. Yeah, my question is based on this issue of exhaustion of local remedies. I am wondering if the presenter might know why the lawmakers could not add add that instead of trying to exhaust local remedies, one can file an application in the court if it can be proven that that one cannot have any local remedy. Thank you. I don't know. It's quite long. I don't know whether you've gotten my questions.
Yes, it's quite clear. It's quite clear, madam.
Okay, thank you.
You're welcome. Do I still have more hands there? Yes, I see Jessica. Jessica, would you like to make your contribution now?
Hello, can you hear me?
Yes, we can.
Okay. Thank you very much, the presenter, for this second module. I really enjoyed your session. My question borders on advocacy, particularly when you mentioned that advocacy can be done during a trial or a proceeding. So my question is, wouldn't it be considered that such advocacy during trial would interfere with the outcome of a matter? In my country, most times you refrain from making statements, particularly concerning a matter, and making opinions about them. Once
Sorry, I think there is an issue with the audio. I can't hear
Okay.
Jessica. Yeah.
Can you hear me?
And I could not hear
Can you
Caroline.
hear me now?
Yes, I can hear you.
Okay, all right. So my question again is concerning advocacy, particularly during a trial or a proceeding, whether it would not be considered as interfering with the outcome of the matter before the court if you make opinions and, you know, for a certain you know, views that you would want to be considered in the outcome of the trial. Wouldn't it be considered as interfering? In my country, I am from Nigeria, you hardly make statements you know, that will kind of sway the public's mind. You know, it will be seen as like playing to the gallery when you begin to make statements, particularly when the proceedings are ongoing. So I just want to know how you balance that kind of advocacy, particularly during a trial. Thank you.
Thank you, Jessica. I don't see any other hand. Oh yes, there is Ventrix Law. Just got in. Ventrix Law, please make your contribution. Ventrix Law, you need to unmute on your end and make your contribution. Please go ahead. Ventrix, I cannot hear you from this end. Okay, let's try AJM. May you please make your contribution? AJM, I'll get back to Ventrix when they're able to speak to us. AJM, would you like to make your contribution now?
Allô, oui. Vous m'entendez?
Oui.
Vous m'entendez? Oui.
Yes, yes.
Merci pour l'opportunité que vous me donnez pour que je puisse donner ou poser ma question. J'ai aimé l'intervention de tout à l'heure de la dame qui a été vraiment claire dans son intervention, mais j'aimerais bien être éclairé par rapport à ce qu'elle a relevé tout à l'heure. Elle a dit que la Cour ne connaît pas des dossiers déjà soumis à d'autres juridictions ou des dossiers, la Cour ne sait pas connaître de ces dossiers qui ont été soumis à d'autres juridictions. Alors, la préoccupation qui est la mienne, c'est celle de savoir, alors, dans les cas où les dossiers déjà soumis à une ou deux juridictions ne trouvent pas une issue favorable par rapport à une partie, ne trouvez-vous pas que la Cour, qui est une Cour de droits de l'homme, empêche à ce que certaines personnes victimes de certains faits de pouvoir trouver une justice par rapport à leur situation? Telle est ma question. Je crois que pendant la formation, j'en aurai d'autres, mais la première préoccupation qui m'a vraiment préoccupé ou qui m'a intéressé, c'est en rapport avec ce que je viens de relever tout à l'heure. Merci beaucoup.
Sorry, could you, Ventrix, could he please repeat the question? Because I'm not sure if it's an issue of translation, but he's saying the court is not aware of the dossier submitted.
Okay.
What does he mean by the dossier? Sorry, maybe it will be a translation.
La dame a relevé lors de son intervention que la Cour ne connaît pas des dossiers déjà soumis à d'autres juridictions. Alors, ma question est celle de savoir, au cas où les autres juridictions devant lesquelles une partie X ou Y avait déjà soumis son dossier, ne donne pas une suite favorable. Parce qu'il nous arrive en Afrique de soumettre X dossier à une juridiction et on se rend compte que cette juridiction ne tarde à donner suite, ou cette juridiction ne traite pas avec beaucoup de célérité un dossier qui lui avait été soumis. Alors ma préoccupation est de savoir pourquoi la Cour a essayé de fermer cet accès à des parties qui veulent lui soumettre un dossier X ou Y. Telle est ma question. Merci.
Thank you. Thank you for the contribution. I see finally Chris, please make a contribution now, Chris.
Hello. Good
Hello.
afternoon. Can you hear me?
Afternoon. Yes, we can hear you, please.
Okay, great. I'm Chris and I'm from Rwanda.
Yes, Chris, please go ahead.
Yeah. First of all, I would like to thank the presenter. The presentation was so grateful. And my question, or my contribution goes to particularly my state, Rwanda, that had submitted application to withdraw from the rules of the court. So I'm asking what happens to the citizens of Rwanda who wish to submit petitions to the court, yet the state has declared that it wishes to withdraw from the court, owing that by the time it submitted an application, there was an ongoing case of Ingabire Victoire versus the state of Rwanda in application number 003 of 2014. Thank you.
Thank you, Chris. Let me get back to Evelyn now. She has a mouthful of questions she has to go through. But I'll give you just about 5 minutes only. If there are outstanding questions, remember we have a general discussion at the end. So I'll give you time to catch your breath, and then you can come back with the rest of the questions to respond to questions and comments in the general discussion at the end. But for now, just pick the questions that you're able to respond in the next 5 minutes. Evelyn, you have the floor.
Thank you. Thank you for the questions. Let me try answer the ones I followed. I missed one person, I think Caroline's question, but if you can type it in the question and answer, I will respond to it. I think I'd forgotten to unmute somewhere, original or something like that on the translation. Mm-hmm. There was a question which was asked about in Tanzania, the fact that there are some people, there are some people we've encountered, so in the same city, so it was surprising. And he asked about the information dissemination strategy of what the court has. Well, I don't work for the court, but I think on their part, they have had sensitization missions. So has the African Court Coalition, so have other CSOs. But obviously you cannot reach everyone. There'll be that one odd person here and there you cannot reach. But this is where exactly also what I was talking about in terms of advocacy. In that even you as organizations, individuals, you look at what can you do. If you're in Arusha, for example, where we live, we have PALU, we have the African Court Coalition. These are organizations that are constantly engaging in activities to sensitize the masses. Even for us, we're a continental organization. We are always holding masterclasses. We're trying to always sensitize. It's also asking not what the court can do for you, also, but what you can do as an organization or individual or activist. So we also have to be careful. I can't speak for the court, but one thing is that they are also limited in that they should not appear like they're soliciting for cases. So in as much as they're impartial, they have to appear impartial. So in as much as they want TSG to file cases, they also don't want to look like they're now litigating. Because we once asked the registrar of the African Court about this, and he said they have to always be careful in that they do not turn into now the litigants or the complainants by now going out there. Because when it comes to impartiality, it's important for the court to remain impartial in order to give judgments that are actually recognized and respected. So in that, I think the burden is on us. What are we doing? Are we doing enough? If we're living in Arusha and we find there are people within Arusha that don't know about the court, then we need to do more. We group up with other people, whether it's individuals, they join us. If you're an individual and cannot work on your own, you join us. We're a membership organization. Join us, work with us, and we'll be able to, when we have our sensitization missions, you can also contribute in part of our, in one of our committees. And there was the issue of the exhaustion of local remedies, whereby somebody asked, does the court take into account urgent situations which need to be addressed when they expect you to file a case after exhaustion of local remedies? To answer that, the court deals with it on a case-by-case basis. And there have been situations whereby the court has accepted a case before local remedies were exhausted. Yes, there's the issue of sovereignty of a state, but when, for example, they always say local remedies should be available, effective, and not unduly prolonged. So in a situation whereby they're unavailable, and as the applicant, you can prove to the court they're unavailable or ineffective, they will admit your case. We had a case of Wilfred Onyango against Tanzania. The court actually accepted the case before they'd exhausted local remedies because it had been ongoing for a very long time. It was becoming an urgent situation. They were very sick in prison, and it was just not a good situation, but they accepted it. So it's just a matter of when you present your case and you draft it, your wording, you need to strategically word it so that it is clear that the national remedies are either unavailable, ineffective, or unduly prolonged. And in your application as well, if it's a grave situation, you can request provisional measures. So it's always important you make it clear why you cannot, because now it's there in the template. The African Court has a template on their website, which you can use when drafting applications to help guide you. You mentioned in that I could not exhaust local remedies because of 1, 2, 3, and 4. And somebody had mentioned whether there was a question on the new rules of procedure, if they're taken into account the Maputo Protocol. I didn't quite get the full question on that one. That's when I sort of went mute in the middle. But maybe we can give the person, or they can type it in the question and answer, and I can answer it there. And then there was the issue of the universality aspect, and that why can't the court just, in order to avoid the whole situation of the Article 34.6 declarations, just say, we have the universality aspect so we can still hold you to account. One thing to keep in mind is these are sovereign states. And not just sovereign states, but sovereign states, some of which are very stubborn. I think in a sense, we need to be realistic about what it is we're dealing with and what our countries are. We have some states that are dealing with their countries as though they're ruling their own backyards in their own homes, forgetting they're actually people, countries, and lives that are involved. So if we speak of the Africa we have as though it's some imaginary Africa out there and not looking at it realistically, we have a problem. There is an issue of sovereignty of states. And a state cannot be bound unless they want to be bound, especially in the case of the African Court. I'll just explain a bit on the issue of the protocol extending the jurisdiction of the African Court. To date, I don't even think anybody has ratified. I think somebody had signed, but nobody had ratified the last I checked. And this is extending jurisdiction of the African Court to cover even some of these universal crimes. But states just do not want to be bound. And you cannot force anyone to be bound. There was even a time there was a discussion of, okay, if they're not going to ratify this protocol extending the jurisdiction of the court, why can't we look at it as the International Criminal Court has this, so they can work in complementing each other? There was such a huge outcry. Firstly, people were not happy about the extension. They threatened to close the African Court. They're like, if it now gets to this, let's just withdraw. We close it and we move on. And then when the issue of, but they can still work in complementarity with the International Criminal Court. Even if you cannot prosecute now at the African Court, at the International Criminal Court, you can, it was another issue. It became another whole long conversation, which the issue is people don't want to be held, they don't want to be held to account, states. So I think it's a matter of what can we do? If they've withdrawn, somebody else asked that question, they've withdrawn Article 34.6 declaration. You look at how, can you still seize the African Court? Yes, you can. It also answers, there's a lady from Rwanda who asked that question, that what do we do when our states have withdrawn Article 34.6? You can still go to the court through the commission. You write your communication to the Secretariat of the Commission, but in that application, you can actually explicitly request it to be referred to the African Court. Because of that complementarity between the African Court and the Commission, it's very much possible for it to be referred back to the African Court. So it's not a completely dead situation. It's just that people need to be aware of that route of going through the Commission to reach the African Court. There was a question on vacancies about people getting feedback, I think. I can't answer that one. I don't work for the court, but if I misunderstood, you can put it in the dialogue box, and then we can always forward it to the court for them to respond to you. And then there was a question of publicizing all these cases. Somebody said, in the national system, there's the issue of sub judice sometimes. What do we do about it? Are we not interfering with the outcome of the court? I'll give for example, the court or the commissioners. Firstly, the first thing they're supposed to observe when they're sworn in is impartiality. And even like looking at the African Court, for example, a judge cannot listen to a case from his country so that that impartiality is not compromised. That's one thing. But in whatever they do, the other judges or commissioners, even if they do watch whatever they watch on TV and they see you doing your advocacy, it should not, ideally, it should not influence them. But the court themselves and the commission, they have press statements. You look at the African Court website, for example, they have a summary of all the cases. But the issue is some do not know about these cases, one. Two, even when they issue the press statements, some don't get a hold of these press statements. And in some countries, you even have so much controls on the internet and everything and the televisions. Some of this is not even broadcast. And some websites are even like blocked completely. You cannot access them. So it's in these situations that we say, one, even the courts themselves sometimes do, like the African Court does public hearings whenever they hold hearings. It's not in every case now, but in some cases. But it's a matter of taking that information, which is already out in the public domain, and disseminating it so it's out there and people get a hold of it. And it is that pressure, because if you've had censorship of your internet, of everything, but there's still organizations now in the country spreading this information, and it is out there and people have access to it. That is the advocacy. It gets to people. So, and it's also a matter of exercising our freedom of expression. It's a matter of just sending the information out and people being aware and raising awareness of the court. I hope that's clear now. But sub judice should not constrain you to the point of failing to disseminate public information that is out there. Hope that makes sense. And the issue Ventrix had raised of the dossier, I asked him to put it in the chat so that I can answer it. And I'd answered the one of countries that had withdrawn the Article 34.6 declaration. If there's anything else I have not answered, please just put it in the question and answer. And I think African Court Coalition also will address some questions which people are not able to address during this session. Thank you.
Yes. Thank you, Evelyn. So at the end, like I said, right now, all questions that have not been answered or even new questions that have been introduced, we will deal with them in the final session. So thank you so much, Evelyn, for the presentation and for your reaction to the
Evelyn, pour la présentation.
More questions will come to you, and we'll call upon you again together with Florencia at the end to talk to us again on those questions and on those comments. At this point, I would like us probably to take, with the permission of the African Court Coalition, about 5 minutes break, because we're slightly running behind time. We'll take 5 minutes break, health break, and we continue at 1:35. Let's just say 1:35. Yes, 1:35 we'll continue. There we'll be receiving our second presenter from the Inter-American System of Human Rights to tell us about the engagement in that part of the world and what lessons we can draw from there, and also what they could have probably up to now learned from how we do our things here in Africa. So let's take that 5 minutes break and let's reconvene at 13:35. That's Arusha time. Thank you. We'll see you later. Welcome back, colleagues, ladies and gentlemen. Let's move on to our next session. And as I already mentioned at the beginning, we have a colleague amongst us who will take us through the presentation on the lessons from the Indo-American human rights system on strategic engagement with the Indo-American Court and the Indo-American Commission. And the presenter is Ms. Florencia Reguiado, who is a senior attorney at the Washington, D.C. office of the Center for Justice and International Law, which is a non-governmental organization, the human rights organization that focuses on strategic engagement with the human rights bodies, which is the subject matter of our discussion today. In her current position, she represents victims in cases before the Inter-American Court, in the American Commission, or overall the Inter-American human rights system as a whole, with a focus on cases from the United States, the Caribbean, and the Andean region. And prior to working in the Washington office, the presenter has worked for the same organization, but focusing on Central America and the Mexico office, and was based in San Jose in Costa Rica. Given her perspective, working with both the Central American and Washington offices, she is a focal point for the organization, that is the Center for Justice and International Law relating to migration and statelessness. In terms of formal qualifications, Florencia holds a law degree or an LLB from the University of Buenos Aires with a focus in public international law. She also holds a master's degree in international human rights law from the University of Notre Dame. And she also completed a postgraduate qualification specializing in migration and refugee law from the University of Buenos Aires. And prior to working with the current organization, Florencia was the Notre Dame Fellow at the Inter-American Court of Human Rights. And during that time, she spent a year as an attorney, assisting in the analysis and drafting of decisions before the court. And has also worked at the Center for Legal and Social Studies, which is an Argentine human rights organization. And she worked there with the social protest program and litigated cases before the Inter-American human rights system. So this is our presenter, colleagues. And again, I have no doubt that we have a colleague amongst us who is familiar with the issue of strategic engagement with human rights bodies. And as I mentioned before, there is also a court and a commission in the Inter-American system. And I think it's a system that we are looking forward to learning from, how they've strategically engaged the system in terms of litigation, in terms of implementation of decisions. These questions which continue to vex us here in Africa, I'm hoping that Florencia is going to deal with those. And I'm looking forward to her presentation. So Florencia, the floor is yours. Please take us through your presentation. You're welcome. Thank you.
Thank you so much. Hello, good morning to everybody. And thank you so much for the invitation to be here
Florencia,
with you.
You might want to unmute.
I'm on mute. You cannot hear me?
You're unmuted.
Yes.
Please go ahead. Please go ahead.
Can you hear me now?
Yes, I can hear you now. Please go ahead.
Yes.
Yes.
Okay. Sorry, I don't know what happened. Okay. So thank you so much for having me here today. I'm, as you mentioned, I'm a lawyer, a practitioner, and I'm very happy to share with you some information about the Inter-American system and the work that we do at the organization I work now. I think that strategic litigation is mostly about like thinking together and share experiences. And I know that the bodies of the Inter-American system and the African system have been having these meetings. And I hope that this is a beginning of something that we have to do in civil society among the Americas and Africa. So I will focus my presentation specifically on the, sorry, I don't know what's happening, the computer. on the engagement of that we have had in our organization with the Commission and the Court. Just to talk to you about a bit about the organization, it's a 30-year-old organization that is we litigate before the Inter-American system in the whole Americas, and we are like the only one organization that do this. So we have like a very broad like comparative experiences among the region. I will provide you with a short introduction about the Inter-American system, and then I will talk about ratification and competence, because this is very, very important to think about the tools we can use in depending the ratifications and competence. And then I will move to the engagement with the Inter-American Commission and the Inter-American Court, but I will only focus on the individual complaint procedure because we don't have more time to talk about other tools. But of course, I'm happy to answer any question if you have any about that. And then I will end with some positive outcomes of the history of the system and some of the challenges that we see right now. So, as the African system, the Inter-American system is composed by two organs, the Inter-American Commission and the Inter-American Court. What you are seeing right now is the current composition of the Commission. The Commission is composed by 7 members. And right now, as you see, there are 5 women and 2 men. This is a recent accomplishment that we have and that we've been from civil society really fighting for, changing the picture, as we said. These commissioners are elected by the General Assembly of the OEAs. This means that the certified states that are part of the Organization of the American States. They're independent experts. They don't need to be attorneys. They are nominated by their governments, but once they are elected, of course, they don't answer to the government, to them. They are elected for a term of 4 years, and they can be re-elected only one more time for the same time. And these are some of the mechanisms that we currently have at the Inter-American Commission. The contiguous jurisdiction, and what I will focus later, the individual complaints and monitoring recommendation, the precautionary measures. Then we have the reports, the country reports that the Commission issues once they visit one country. They can go to visit the countries if the government requested. Sometimes it's also like civil society that requires this to the Commission, and they ask the governments to visit the countries. The follow-up reports that they make about the situation on a certain country, that they do this on their annual report every year. And then the thematics report, that they have many reports about human rights defenders. They just released one about business and human rights. They can be also like regional situations that they talk about in this report. And they have other tools as resolutions that, for example, in this current context of the pandemic, they issue, I think, two resolutions about how states should address the situation to respect and fulfill human rights during the pandemic. They also provide with advisory service to people, press releases and Twitter releases, that this in the last couple of years has been of really helpful for all the organization. To provide with visibility about an immediate visibility about some situations that were going on. Statements, they also have thematic hearings. For example, on Monday, I participated on a thematic hearing about illegal intelligence in Colombia. And they have the special rapporteurs that they cover different thematic for example, migration, old persons, disability persons, yeah, indigenous population, women. There are many. So moving forward to the court, this is the current composition of the court. The countries that you can see mentioned there are the countries where the judges come from right now. There are also 7. Unfortunately, in this picture, we only have 1 woman and 6 men. They are elected by the state parties to the American Convention. This is a big difference with the Commission. And they have to be attorneys or lawyers, and they are elected for a period of 6 years and can be re-elected for 1 more period. The mechanisms that we have at the court is, well, it's a contingent organ, so it doesn't have like this political possibility that the Commission have to express more freely. So it has less mechanisms. The notorious one is the individual complaints. They also have the provisional measures and the advisory opinions that is, well, Evelyn mentioned that you also have the African system, and this right now is being used a lot by states. Also to discuss some political issues in the region, like for example, we recently have a submission made by Colombia to talk about the situation in Venezuela, and now the court has to decide about that. And we also have other tools like press release and statements. So, and here you can see, well, that I try to put together the different mechanisms that we have in the different systems, and in the African and Inter-American system, we kind of find the same or very, very similar. And in the European system that they have very, very less mechanism as the ones that we have. So moving forward to the ratifications and competences, as I mentioned at the beginning, this is very important because depending on the ratification and competences in our system, it depends on the tools we can use, but it's also important because from civil society, we do not promote like any changes to the convention and to the normative framework that we have right now, because we don't want states to make changes that will be less protective to us. I'm talking specifically about the US and Canada, for example, that, as you will see now, they didn't ratify the American Convention. But before going to that, you can see here that we have a very broad and normative framework that the Commission and the Court can use and been using to protect and provide with reparations to all the victims in the region. So this is the difference that I was talking before. We have some countries that have not ratified at all the American Convention, and so the only instrument that can be applied to them is the American Declaration. This is the situation of the United States, Canada, Cuba and Venezuela. But well, Venezuela is in a different situation because they left the OEAS and now they came back. Well, the new government ratified again the convention. So it's a sui generis situation, and we really don't know how this is going to develop in the cases that we currently have against Venezuela at the Commission and the Court. So in the case of these countries, the only one that can decide a case against them is the Commission. This is because in the American Declaration, the only organ that is mentioned is the Commission. The court, as I talked before, was created after, 20 years after. Well, was put into functions 20 years after. Then we have the states that ratified the American Convention but did not accept jurisdiction of the court. We only have 3 countries in this situation. And also in this case, it's only the Commission, the one that can decide cases against them. Unfortunately, the cases against these countries cannot be decided by the court. And finally, we have the countries that ratified the American Convention and accepted the jurisdiction of the court, that are 22 of 35 states of the Americas. So, yeah, this is, and I will talk later about the situation of the states that did not ratify the American Convention and did not accept the jurisdiction of the court. So you can see more like the importance about this and how this impacts in the realities of their countries. So moving forward to the engagement with the Commission and the court, I'm going to focus on the last part of the process at the Commission, that is the issuance of the merits report. But as Evelyn was mentioning before, this is similar in the American system. We also have an admissibility phase and a merits phase. So a person or organization can submit a petition to the Commission. The Commission at the beginning will transfer this information. Will review, of course, all if the petitions complies with all the requirements, the formal requirements, and if this is okay, they will transfer it to the states. And once the states answer, they will issue admissibility or an admissibility report. If they issue an admissibility report, the case moves to the merits phase, and in the merits phase, the petitioners have to submit another brief. Another time they request the states an answer. And then finally, the Commission decides and issue a merits report. The report of the Commission establishes the facts, the violations to the American Declaration or the American Convention or any other inter-American instrument that was ratified by the state. And once they do this, they transmit the report to the parties, to the government and to the petitioners. To the petitioners, they request their positions about remedies to the victims, and also their position to, if we agree to submit the case to the court or no. They request this information about remedies, usually because the report of the Commission has at the end some recommendations on how the state should repair the victims, but these are very, very general. The idea of the Commission is to leave the victims decide what reparations they want. So, for example, what they say is like provide with full reparation to the victims, to investigate what happened, to adopt administrative or legislative normative. But I mean, this is really open, and it's a good opportunity also for us to begin to think on and to talk with the victim about what reparations are important, and this is also important for the stage at the court, right? So initially, when the commission transferred the report, they provide the state 3 months to demonstrate progress toward the compliance of the recommendation. And after that, the commission can decide to extend the time for the state. I mean, if you think about, sometimes it can take a long time to have a merits report from the commission, 10, 15 years maybe, but also like 3 months to comply with recommendation. It could be short for the state, to at least to demonstrate like some reparation, substantive reparation. So they can decide to extend the time. They can also submit the case to the court, or they can decide to publish the report. In the cases of the countries that cannot arrive to the court, this is the last option they have, to publish the report, the merits report of the commission. And I will go on deep later on that. So what are some of the strategies that we have and the state has after the issuance of the merits report and before the submission of the case to the court? Well, the state, of course, wants to avoid the case to reach the court, right? So they will try to request as many extensions as they can. The practice of the commission has been like not to provide with more than 3 extensions to the court. We have at least one case and they provide 4 extensions, and yeah, we complain about that with the commission. And this means that usually it can take at least 1 year since the commission issue the merits report until the case is submitted to the court. Another strategy that the states have is to submit tons of documents. So the commission that has to decide if they provide with an extension or send the case to the court in a short time, they have like more difficult to review these documents. And also when they submit this document to us, it's difficult to decide and to see if they are like addressing the recommendations of the commission, if they submit so much information in a short time. Well, another, like I would say, it's not a strategy, but something that we have seen in the last year is the professionalization of the state defense team. And I would say also that they are also talking to them more frequently and like seeking, as we are talking right now, and they are also having their own roundtables. And in fact, more than that, they have also like sent like public letters complaining to the commission about the system. In this instance, it's also common for the state to enact or to send information to the commission about the national policies on remedies for victims of human rights violations, to see that they are doing something to repair, like not only the case that we are looking or we have before the Inter-American system, but also other victims. This is something that, I mean, at least in our case, we have seen that it's a good practice, but what we always answer to that is that it's good, but this is a victim that submit the case to the Inter-American system, and the Inter-American system has the faculty to decide what remedies they want to for the victims. So these are some of the strategies of the state, of us victims and their representatives. Well, this is a key moment to try to negotiate a friendly settlement with the government. Usually they are more open to accept the well, it depends on the state, I would say, but some of them will be more open to accept the remedies that we propose for the victims. We usually try to seek for an integral remedies, I mean, all type of remedies. And yeah, this is a really, really good moment. And also another thing that we've been doing in the last year is requesting for working meetings that are private meetings with the Commission and the state to try to address the recommendations of the Commission and try to provide with a quicker reparation for the victim. We also requested in some cases public hearings. This is not very common at this stage, but yeah, we have done it a couple of times. So moving forward to some of the practices of the Commission on sending cases to the court. Well, one thing that is important to say is that in the last couple of years, the Commission has sent more cases to the court. They increased the number, I could say, but they decreased the quality, and they are shorter. Usually, the reports of the Commission had around 50, 70 pages, and right now I think they have a limit of 35 pages, and you can see merit reports that are 17 pages. Well, as you can imagine, for a victim that waits 15 years or 20 years to have this merit report, this is not a really good way to end this process. So usually the Commission, what takes into consideration to submit a case to the court is the victim's will. This is the most important reason why they submit a case. And I'm telling you this because this is why in the Inter-American Court, we can see some repeated or common topics in the decisions of the court. For example, we have many decisions about enforced disappearance in Peru, in Colombia, in Guatemala, the same with torture, or with, for example, violence against women in Mexico. I think we have 4 or 5 decisions. And this is something that states usually complains about, because they say, why, if this is the last, the Inter-American system is the last step, why why you have to send all the cases to the court? And in fact, in the last year, we had a couple of challenges with this. The Commission tried to leave the case at their stage and to publish some cases, and we have to litigate this with the Commission to try to avoid it. Well, as I mentioned, another practice of the Commission is to provide the state with extensions to advance in the compliance. And it usually takes 1 year. It can take longer. If both parties agree that they want to continue at this stage with the Commission, trying to find a solution at this stage, they can seek for more extensions. I know, for example, a case that I think they have 17 extensions, and it was at that stage for many, many years. So, and what happened if the commission decided to publish a report? Well, of course, this means they decided not to submit the case to the court, or in the cases that states that have not ratified the American Convention or the jurisdiction of the court is the last phase. And in this case, what we have done, especially with the United States, in this case, we want the report to be published as soon as possible, because this provided the situation with more visibility, and it's also an important tool for advocacy at the national and international level too. And in this situation, we also request some working meeting and public hearings with authorities and the commission. The merits report publication, it will appear every year on the commission's annual report. They will monitor the compliance of the state annually. They will request us and the state information at least one time per year. And in our experience, well, of course, you have less leverage at this stage because once the report is published, you cannot do anything else. I mean, so you have to, I mean, you cannot go to the court. So yes, it's hard, and we always try like to complement these published reports with advocacy and communication strategies. And finally, finally about the commission, in the last couple of years, the commission tried to address all the recommendations that they have on friendly settlements, published merits report, country report, thematics report, and granted precautionary measures. They recently launched this website that you can see the screenshot in the screen. And they put together also a follow-up team to be more like to work more better, I would say, in all the recommendations they have issued, because in a couple of years ago, it was really like complex to understand what they have said in a thematic report, if it matched what they said on a merits report, and there were several inconsistencies. But well, in my experience, this is really, really new, but it has a lot of challenges. As I was mentioning, there are inconsistencies in what they say on the individual complaint systems and what they say on the thematics report. And these sometimes can be like on benefits of the state, that they can say, well, see, the commissions on this thematic report or country report, they say that I'm not violating anymore the right to nationality in the Dominican Republic, for example. But if you then go to the cases, you can see that they are still saying that the situation is the same in the Dominican Republic, and the court also says the same. So this is really, really complex, but they are trying to address the situation, and they've been having like working meetings about cases and country situations with the court, with experts, with also in public events and with key actors in the last years. So this is all about the commission. And now moving forward to the engagement with the court, I will briefly mention the procedure at the court, because also it's similar to the African system, and then I will focus mostly on some of the state's arguments to prevent the court to decide the case and our strategies to deal with that. So as I mentioned before, the commission is the only one that can decide to submit a case to the court. But once the case is submitted, the role of the commission, and this is because there have been several like changes on the rules of procedures of the court and the commission. The role of the commission, it becomes like, I would say like secondary. The petitioners have more an active role in the procedure. In fact, this is not something really good, but in the last years, the role of the commission, for example, in the hearings, we have like 2 hours and they have like 15 minutes to talk at the hearings before the court. So another important things to know before we begin with the procedure at the court is that the factual framework of the case before the court is given by the merit report of the commission. And you will understand why I'm mentioning this after. So the court, when a case arrives, they preliminarily analyze the case, they review the file, annexes, and if everything is okay, they contact, I'm sorry, they contact the representatives of the victims, they request their powers of attorney, and after that they send us the official submission of the case, as they call, and we have 2 months to present our brief of the case to the court. After that, the state has also 2 months to present an answer to that and to also oppose preliminary objections. And if the state does it, we have one month to answer to that. That is usually like very, very common that they at least present one preliminary objection to the case. After that, the court calls for a hearing. Well, it's discretionary that they can or cannot call for a hearing, but usually the common practice is that we have a public hearing to hear the victims and also the oral arguments of the parties. Sometimes, especially like in the first years of the court, they did have a preliminary objection hearing, and they decide the preliminary objections, and then they move forward to the case. But in the I would say in the last 10 years, they only have one hearing of both things, and they only have one decision, in fact, that decides everything, like preliminary objections, merits, and remedies. It's as this is I think one of the biggest difference in the Inter-American system. It's not very common that the court decides that the case is inadmissible, they do admit some of the preliminary exceptions that the state has submitted, but I think we only have one case that they decided inadmissibility of the whole case. So, and moving forward to some of the arguments that the state has to prevent the court to decide. Well, we have the same procedures of exceptions, the non-exhaustion of domestic remedies, ratification dates, a deadline to submit the petition. But this has been really good covered by the court. It's very uncommon that one of these exceptions move forward. But the state has been really creative with the preliminary objections they have submitted to the court. I will mention some of them, but there are many. The most common is the serial error by the commission, that they argue that, and many states submit this exception. They say that the commission violates their right to defense, and the excuses have been many. For example, differences between the admissibility and merits report, which articles of the American Convention have been decided at the admissibility report and which of them have been decided at the merits report. They have also used the delay of the commission, the backlog of the commission to decide a case as an excuse to violate their right to defense. Factual inconsistencies between the petition and the merits report. This is something similar to the first excuse that they said. They also allege that the case was submitted to the court by their request because the commission was not considering how well they were doing on implementing their recommendations. So they request the commission to submit the case. That of course is not true. One thing that is very, very common in the last years is they talk about the principle of complementarity and subsidiarity, and usually here they mention again the domestic remedy laws, and that the court has to take into consideration these laws. They also complain about the context or facts or the victims' names if they were not included by the commission in the merits report. This is why I was mentioning at the beginning that it's really important to remember that the factual framework of the case is given by the merits report. They usually try to not move forward from that merits report, and this is a big challenge for us because since we litigate structural problems in the countries, we want the court, of course, to decide about the context in the countries, and it's been especially in the last year, very, very hard to have the court mention the context in a broad sense in the decisions. Recently, they also, to avoid having a public hearing, they say that the victim was already heard by the commission because there was a public hearing on the merits at the commission. And they also, this context of the pandemic, they say that it's impossible to conduct a hearing. In fact, well, right now we are having some challenges on that, but we are moving with the court to Zoom hearings. In fact, we have one yesterday. Yeah. So, and well, finally, are some of the positive outcomes and challenges that we have at the Inter-American system. Well, I think in the whole history of the system, it's been very, very important to involve the states in the dialogue and to find like also ways to advance in the procedures, to also modify the rules of procedure, not the convention, not or other instruments, but the rules of procedure. And also to create more spaces of dialogues among local actors, especially at the Commission. And of course, to provide redress to the victims, create awareness of an issue. Even if like sometimes the decisions do not come out as we expect, is a good tool like to develop advocacy and communication strategies and give visibility to the issue. To change also patterns in the countries, and to create additional guarantees of non-repetition. The court has been incredibly good creating like some non-repetition measures, giving legitimacy to a claim, also change internal laws and constitutions, and many countries have been able to do it because of the court or commission decision, and prosecution and punishment of the perpetrators, and also like protect persons in danger. The challenges are many. Well, I would say that state dialogue and coordination is increasing, and I mean this hasn't like to be bad essentially, but it can be, and at least in the last year it demonstrated that it is. The selections and commissioner and judges, this is also a challenge that we have. The way in which states have find also to be more involved in the system is to submit profiles of people that are politicians and sometimes, and not like lawyers or people that are like human rights practitioners or that know about international law. We in the last year we also developed some groups to monitor this, and before the election takes place, we also like try to publish information about the candidates. So at least in this way, we prevent some of them to arrive to the commission and the court. Compliance, unfortunately, the decisions doesn't mean to comply immediately. The states also sometimes do not answer. Sometimes they do not attend hearings. Of course, I'm not talking about all of them, but yeah, of course, the ones that we have like the worst human rights situations is the ones that are not attending hearings. For example, Venezuela. The political crisis in our region, Venezuela, Nicaragua, the US, Bolivia, Brazil, it's also a challenge, and the countries are also like divided among them, supporting one or other parties. The coordination between the Commission and the court is another challenge. They are trying to work on this, but at least that I know, they only meet one per year. So I think this is not enough for like the amount of cases and work that we have at the system. The funding and human resources, the way in which the Commission and the court is funded is by the money that state have to send to the OEAs, and many of them for several years haven't seen anything. So this is another challenge. And
hello, can you hear me?
Sorry? Yes.
Now I'm connected.
Oh. Human resources. The Commission and the court has like a very small group of specialists working on many cases. If you think, for example, the Commission, I think they have 100 people and they receive 2,000 petitions per year, and I'm only talking about individual complaints, not about other tools. The statistic and results they have like to also to provide, and as I was telling you before that, for example, the merits report now are shorter, and this is because also they are trying to address the backlog in this way. Well, the backlog and the professionalization of state defenses that I also talk about before. So these are some of the few challenges that we have in this region. And thank you. That would be all.
Thank you, Florencia. I unilaterally decided to give you time that you need so that you are able to, take us through your presentation. We treasure your presentation very much because by looking at your system, we are also self-evaluating our own system. How does it, compare with other regional systems? Where are we doing well? Where are we doing badly? What can we learn from others so that we make the work of the court, the work of the commission effective for our people here in Africa? Thank you so much for taking us through this. And I have no doubt that your presentation as presented, and of course the slides that will be shared with the participants, they'll find them to be very useful and very informative in terms of how that system works. Not only that, in terms of the jurisprudence that you're talking about, that has been produced in that very wonderful jurisprudence. I always see it in my research when you're looking at specific issues like disappearances, you're talking about enforcement disappearances, state responsibility, how that principle was developed in that system. It's very, 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 very informative. And our system is already, in fact, imported some of those principles into how do you define state responsibility in a given violation of human rights? How do you say the state is liable when in fact it is the actions of private parties, for instance, of private actors? We find that very innovative in terms of how it has developed in your system. So for me, I was going to jump to the issue of how we can strategically engage our system in terms of implementation of decisions of our court and also of the commission. And the question that I'll put to you is to say, what role have you seen national actors play? What role have you seen national actors play, including lawyers? Like most participants who are participating in this webinar, they are best at the national level, and that's where they work. Some are lawyers, legal practitioners, some are in the civil society, maybe some are in the media, and so on and so on. But what kind of role did you see players in this Indo-American system playing in order to enhance the implementation of the decisions of the court. And by extension, of course, probably also implementation of recommendations of the commission. It's something that we will probably speak to as we enter into our last phase. We always merge the last phase, you know, the last speaker's presentation, the answer and question segment, we always match it together with the final general discussion. So you can take note of that question. I'll give you a chance to respond to it, among other questions and comments that I think my colleagues around the continent and around the world will be able to put to you as far as your presentation is concerned. At this point, allow me to invite questions and comments on Florentia's presentation. Any clarification that you need to clarify, or just reaction, the comments, maybe comparing the two systems, how they've been operating, but more importantly, how the Indo-American system has been operating so far, so that we can also enrich our own system. So the floor is open for contribution and for questions. I'm looking at hands. So probably Florencia, go ahead and probably just your reflections on the questions that I put to you on national actors, the role that we can play at national level. I mean, the role that players at national level have been playing in your system to assist the implementation of decision of the court or of the commission.
Sure. Yes. Well, thank you so much for your comments. And yeah, well, answering your question. First of all, I would say that in our organization, we always litigate the cases with national organizations. So they provide the information about the context and the situation in the countries. And we have the expert on the litigation at the Inter-American system. And this is very useful because, of course, they know better than us the local actors, the stakeholders. And it's also easier like to contact the press and know how to move in each country. Each country is really, really different. But engaging, well, I think you were mostly speaking about authorities, right? In the way we engage them at the commission level, it depends. In the cases, for example, if we have a reparation about health, for example, we usually request someone from the Ministry of Health to attend the meeting, and not only the representative of the state before the Inter-American system. This is something that is like that we've been like developing. It's a practice. It's not like written in the procedures of the commission, unfortunately. But this is something that we've been like trying to do, to have like an authority that can decide in that space how to move forward with the case and try to advance in the implementation of a decision. It can be also with a precautionary measure, for example. And in thematic hearings, for example, that are public, it depends on the subject that we are covering in the hearing, but we try to do the same, right? To engage with national authorities in that space. At the court, the monitoring compliance is mostly written when you have a decision, and you can request hearings. In fact, this hearing that I was talking to you that I had yesterday was a monitoring compliance hearing against Peru, but it's mostly written. And we in this case we also try to do the same, try to request a specific information from the Ministry of Health, from the Ministry of Agriculture, from the legislative power about a law that has to be enacted, from the prosecutor if we are talking about justice. We also try to, when we visit the countries, I mean, because I'm based in DC, and when we go to the countries at least one time per year before the pandemic, we try to have like events or meeting, at least private meetings with authorities. Sometimes we also attend that meetings with the victims. So the victims, we found out that it's more powerful, like to have the victim's voice in that spaces, so the government can still like see how the victim is struggling because they didn't like repair or provide with the remedies that the court of the commission decided to. I can talk more about compliance if you want, how the procedure at the court is. I mean, but I think like mostly like talking about an national engagement is, and something that is interesting also, especially, well, both, I would say the commission and the court, that they have been doing in the last years is that they invite, for example, UNHCR or the High Commissioner to the thematic hearings. They also, the court especially, they've been requesting in certain cases, the presence of the ombudsman in the hearings of compliance, or they request the ombudsman to provide with information about a specific measure that they order on their decision. Yes, this is, well, some of the strategies that we have right now.
Okay, that's fine. I think that's very, 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 point on point to the question that I'd put across to you. I'm hoping that I've seen a couple of questions in the chat box here in French. Laurencia, how good is your French? I think you're muted this time. I can see you're muted. I think the interpreters will help us interpret or translate some of the questions that are in the chat box. But as they do that, I just wanted to get a sense from you, Florencia, as far as the issue of withdrawals of state parties, from the American Convention is concerned, whether that has happened and why it happened, and also how the court dealt with cases either pending or filed soon after withdrawal, how that issue was handled in your system. That would be the first question. The second one, before you move on to answer it, is you mentioned the relationship between the court and the commission, there being big room for improvement. I wanted to know what is the nature of the challenge or challenges in terms of the working methods of these two institutions. What is the nature, to the extent that you are free to share those details? What is the nature of the challenge in this relationship, in this cooperative relationship? Because when we look at the institution from a distance, we think it's a perfect system. We think the commission and the court are working together. It's a perfect relationship. But we are hearing from you, from the horse mouth, so to speak, that there could be challenges. So if you could particularize those challenges and how they are being dealt with. And lastly, I think it goes to your organization, the center, in terms of, if you could share with us maybe a couple of cases that you think were strategic, that you have participated in, whether providing technical support to those who were prosecuting the cases at the national level, like you mentioned. That you'd say these ones were strategic and in this sense, so that we have a better understanding of what is meant by strategic litigation, what was the strategy, what was the outcome that you intended to achieve, probably, and how was that achieved through that litigation. So those would be my three comments or questions. But I see the chat box is getting active now, so you can go through these as I prepare more for you, in a sense, in a way. Florencia, you have the floor now.
Yes, sure. So beginning with the states that denounced the convention, and the convention, and they in the case of, I will refer to the case of Venezuela because it's the most recent one and it's the only that moved forward. In 2012, Venezuela decided that they will withdraw from the jurisdiction of the court. So this meant that they say this in September of 2012, and they did it like according to the rules of the convention. So it entered into force in September of 2013 because it takes 1 year to take into force. What meant is that every person that victim, organization that wanted to submit a case against Venezuela had to do it before September of 2013. But it doesn't mean that the commission or the court can continue to decide cases about Venezuela or Venezuela. In fact, right now I have one case against Venezuela at the court that I hope that at the beginning of next year we will have the public hearing. But what happened with Venezuela is that, well, I don't know how familiar you are with the political situation in Venezuela, but right now they have 2 presidents. So in 2016, the Maduro government decided they will withdraw from the whole OEAS. But then Guaido, the second president, arrived, and the General Assembly of the OEAS decided they will accept Guaido as the representative of Venezuela before the OEAS, because also the Maduro government left. So Guaido came and he ratified the American Convention again and the jurisdiction of the court. So right now, but the thing is that in the practice, the commission and the court still send information about the cases to the Maduro government. So we really don't know how is this going to finish. And that's why also I was mentioning that one of the challenges that we have is the political crisis in our region and how also the other governments are moving, because I really don't see how we are going out of this situation with Venezuela. So yeah, that was the only case that we have an actual like withdrawal. We have some threats in the past. Peru was one of the threats, I think, at the end of 1990. It was because they had, the court has many cases against Peru. I think it's the country that has more decisions against Peru and Colombia, I think. So that was one of the reasons to threaten with this withdrawal. And well, and right now we have also a really sui generis situation with the Dominican Republic. That is that after the court, and I will talk about a strategic case about the Dominican Republic and to connect with this. In 2014, the court issued a decision called the Dominican and Haitian expelled from the Dominican Republic. That it's a big case, about racial discrimination and against Dominicans of Haitian descent in the Dominican Republic. And when the court decided the case, the Constitutional Tribunal of the Dominican Republic had recently issued a decision where they stripped nationality to all Dominican of Haitian descent from 2010 until 1929. So they stripped nationality from all these people. Since the case was at the court, we submit this information to the court before the court decision. So the court decided about this, the Constitutional Tribunal decision. And after that, when they informed about the decision, 10 days after, the Constitutional Tribunal of the Dominican Republic issued a new decision saying that the court the ratification of the jurisdiction of the court wasn't done according to their domestic procedure, so that they cannot answer to the court and they cannot appear anymore at the court. And since 2014, the Dominican Republic has not answered anything, any written report to the court. And last year we have a compliance supervision hearing, and they did not attend. This I know this sounds terrible, but this year, sorry, they have elections, and we have a new president in the Dominican Republic. And as Evelyn mentioned in her presentation, context in strategic litigation is so important to take into consideration. So right now we have a different party, a new person that is not from the most known parties of the Dominican Republic. So we right now are seeing some good path, and we are trying to develop a new strategy to move in the Dominican Republic. So these are the two examples that I have about threatens and withdraw from the system. Then moving forward to your question about the relation of the Commission and the court and why this is a challenge. Well, I would say that mostly in the compliance stage is a challenge. And why is a challenge? Because, well, the Commission is making all these efforts to develop this group that I was talking about in my presentation. And the court also developed a compliance group, but they are not coordinated how they are working, how they measure compliance. They don't have any a statistic or objective way in which they can measure compliance. And by measure compliance, I don't mean paying something to the victims. I'm talking about how you can measure that it's being justice. You have 1, 2, 3 people in jail, or you have to look at the whole chain of command. These are things that the court hasn't addressed, and the Commission neither. And what is something that we want to avoid is they having different opinions about the compliance. I don't know if this makes sense. So yeah, and unfortunately, the resources also for compliance for the court and also for us for working on compliance are less, and because it takes a lot of time, sometimes you also need to be in the country. Even if we have local partners, it's difficult. And yeah, and with a case I mean, the court has, the commission, I don't know how many cases they have in compliance, but the court has at least 200, and I think they have 5 people working on the compliance group. It's impossible like to work like really like close to the cases and to find like with creative and solutions to deal with the same obstacles that you can see in the decisions of the or in the compliance. Sorry, if you don't have the human resources and to do it. And also, these are, as us, we are mostly like attorneys or human rights specialists, but they are not persons that know about public policy. They are not persons that know about statistics. And I think this is something that is also like, at least in the inter-American system, is something that we are looking that is missing. More people that is not only a specialist in international law, but that knows how to change the policy, how to also like, and also with capacities to conciliate and work closely with the state authorities, right? So this is why I think the relation of the commission and the court, it has a lot to improve still, unfortunately. And about the strategy, some of the strategic cases, well, one of the strategic cases was the one that I just mentioned about the Dominican Republic. Let me think which one of them I can talk about.
You can put your thoughts together, Florence, as I add more to your menu of questions that are coming through from the participants.
Okay.
I see. Yes, thank you. I see one here from General Bertu. Please forgive the pronunciation. You know, African names are rich in meaning and in language. In the Indo-American system, what strategy has been put in place to ensure compliance with the reasonable period of time? I think it's compliance within a reasonable period of time as a possible reparability of damages before both the court and the commission. I hope you're getting the sense of the of that question. It's there in the chat box, so you can have a look at it. But I also want to give Sophia Ebi a chance to contribute, as well as Caroline afterwards. Sophia, would you like to make your contribution now?
Yes, Teresa, thank you. Okay, so my question to Florencia, I would like to know, or maybe if I can at least give a background on our African system, given the recent trend that we've seen of states withdrawing from Article 34(6) of the declaration, which actually gives direct access for individuals and NGOs to file cases directly before the African court. The feasible channel that is there is the African Commission, where people can actually file cases before the commission, and then the commission transfers these cases to the African court. But then again, we've seen challenges to that as well. Up to now, we've only seen 3 cases, which have been transferred from the commission to the court. So apparently there have been a lot of technical issues. So my question is, how does the Inter-American human rights system been able to deal with this? Because as the way it is, with the Inter-American human rights system, it's only the commission that can transfer cases or can file cases before the Inter-American court. And I kind of have a sense that for us, this is where we are heading, because up to now, you only have 6 states which have deposited the declaration that gives direct access for individuals and NGOs. So I would like to know, how has it been able to work out with the Inter-American human rights system, because it seems like it is working. Like you have the commission that transfers cases to the Inter-American Human Rights Court, but then for us, up to now, we've only had 3 cases which have been transferred from the commission to the court. And this is the, you know, the feasible channel which litigants or CSOs can actually use. But then again, we have lots of technical issues. So I would like to hear from Florencia on how in the Inter-American human rights system this has worked out. Thank you.
Thank you, Sophia. Caroline, and then Jennifer will follow after, soon after Caroline. Caroline, can you make your contribution now?
Hello,
please?
are you getting me?
Yes.
Yeah, my question to Florencia is, if I got her well on the elections of commissioners in the commission, she said those elected are not necessarily attorneys. What are your personal impression, or what is your personal impression on those decisions? Do they reflect actual decisions in any litigation process?
Okay.
I think we've lost Caroline. Caroline, are you still there?
Yeah, I'm there. Are you getting me?
Yes, now we do. Have you finished your contribution?
Yeah, just the one question, please.
Oh, okay. Thank you so much.
Do you want me to repeat the question?
Florencia, did you get the question?
I just want to make clear that if I understood it, your question is if these persons that are commissioners are not lawyers,
yeah,
decide the cases.
Yes.
Yes, they do.
No, my question is, what is your impression about the decision? Do they reflect actual decisions in any litigation process?
Yes. Yes, yes. I don't see. I mean, I think it depends on the case and the report, but in general, yeah, I don't see like any. I haven't seen that problem yet. Also because, well, I think in the African system it's probably the same, right? They have the secretariat that are the peoples that work with them on the cases, and yeah, so that they provide with the whole assistance to write the decisions.
Nimeingia lakini kama nani? Yeah. IT.
So, and now moving to Sophia's question, well, yeah, we don't have the direct access to the court, and that's not going to happen in our system, I don't think, because what I was telling at my presentation, this will we will have to change the convention to do it, and we, at least as we are not promoting this because it's the only, we don't want states to make bigger changes. So this is why, and I mean, I don't know, I can't imagine, since we don't have the problem of the inadmissibility at the stage, at the court stage, I cannot imagine how many cases can people, organizations submit directly to the court. If we think that they submit at least like 2,000 cases to the commission per year, so yeah, and I don't know, Sophia, if that answered your question. I thought something else, and now I'm not sure. Okay.
Okay. Yes. You want to move on to the next question, Florencia?
Yes, can you, I didn't understand that question, the first one, sorry.
Or from Caroline, was it from Caroline?
No, the first one, the one you told me that was in the chat, but I couldn't.
Or the chart, on the chart, it says, in the Indo-American system, what strategy has been put in place to ensure compliance with the reasonable period of time as a possible reparability of damages before both the court and the commission? I get the sense that number one, he wants to know the strategy in place to ensure that there is prompt compliance. Depending on what the court has ruled or the commission has also recommended, whether it's reparations, whether the damages, what has been put in place to ensure that there's prompt or there's implementation within reasonable time. Probably something that you've already spoken to in a way.
Okay. So usually when the courts issue a decision, they establish like a time of period in which the state has to submit a report because it's written the process, and also a time in which they have to comply with the decision. In some of the measures of reparation, it's easy, right? Like, for example, well, in some countries, it's easy. Like payments, like health, like scholarships. Those are things that usually states tend to comply, like in a shorter time, I could say. Not all of them, but mostly, like all of them. On the other cases, like for example, investigations, or if they have like to look for a person that is disappeared, what they usually say in the decisions is that they have to do it in a reasonable time. The meaning of reasonable time is not clear, unfortunately. In our experience, at least, in the case of justice, it's easier. Well, right now it's easier, but it takes long time. Also, for example, if we talk about cases of Peru that were decided by the court in 2000, for example, the Barrios Altos case or La Cantuta, that maybe you are familiar with because are really, really renowned cases. After 20 years of supervision of compliance, we have seen that Peru advanced in justice. Most of the perpetrators are in jail, but in 2018, for example, Fujimori was the dictator, was released from jail. So we have to rush to the court and request a supervision of compliance hearing with all the national organizations and request the court to have like a resolution of compliance about this. And when the court decided, it was like 6 months after Fujimori was released. And the court basically said that the national authorities had to decide if the decision to release him was okay according to the international standards. And when the national court decide, they decide that this was not according to international standard and he has to go back to prison. But he was 1 year outside jail, right? So it depends. But I would say that it definitely, I mean, and at least the studies that we've been trying to do about specifically about justice, it demonstrates that the Inter-American system has an impact in providing justice to the victims especially in these cases, right? In the enforced disappearance, torture, extrajudicial executions.
All right.
I don't know.
Yes, we are past our time, 8 minutes, but I see, 3 final hands that are raised. Jennifer has been raising a hand for some time, and I want to give a chance to make a contribution now. Jennifer, can you make a contribution, please? Jennifer, unmute and make your contribution, please. Okay, Jennifer is still muted. May I move to Yare Fall? Would you like to make a contribution now? I'll go back to Jennifer later if they're able to unmute themselves. Yare Fall, please make a contribution.
Mais je souhaiterais poser une question plutôt pour avoir des informations sur la Cour interaméricaine des droits de l'homme. Nous le savons, le problème de ces juridictions, c'est l'effectivité des décisions qui sont rendues par ces différentes cours. L'expérience a montré qu'en Europe, ça fonctionne plus ou moins bien. La Cour européenne des droits de l'homme arrive à obtenir l'effectivité des décisions rendues. Alors ici, en Afrique, nous le savons tous, les décisions peinent à être appliquées et sont souvent contestées par les États qui, pourtant, ont accepté d'aller au procès, de se défendre et, au bout du compte, de refuser de...
Sorry, Mr. Fall, we are not getting an interpretation, and the presenter is not getting any interpretation in English. IT, is everything okay? Yeah, I can't hear
Vous
you.
me parlez en anglais, je ne comprends pas ce que vous dites.
Hello, Louise, kindly interpret.
Yes, I think Louis is there now. Louis, are you there?
I'm sorry.
Louis, is Louis still with us to interpret for Mr. Fall, please? Okay. All right. Please, Mr. Fall, continue with your contribution, please. Someone will interpret in the chat box. Please go ahead. Rebecca, please take note.
Ben, je vais devoir peut-être reprendre. Je ne fais pas une contribution. Je souhaiterais avoir des informations sur le fonctionnement de la Cour interaméricaine. Et je disais tout à l'heure que, aussi bien ici en Afrique, au niveau de notre Cour africaine des droits de l'homme, qu'au niveau de la Cour européenne, l'effectivité des décisions rendues par ces cours pose parfois des difficultés. Qu'en est-il de la Cour interaméricaine? Est-ce que les décisions sont facilement acceptées par les États partis? Voilà, c'est ça ma question en fait. Parce que nous sommes confrontés, nous, ici en tout cas, à l'effectivité des décisions rendues par les cours. Et pourtant, les partis acceptent le procès, vont au procès, se défendent, mais par la suite contestent les décisions qui sont rendues. Qu'en est-il pour ce qui concerne la Cour interaméricaine? Voilà, c'est ça la question. Merci.
Merci beaucoup. Merci beaucoup. Misha, please make your contribution. Misha, are you there? Please make a contribution.
Thank you. My question is, when the states in the Inter-American system withdraw or offer some kind of pushback against the Commission or the court, how does the OAS as an organization respond to that, if at all? And how do other states within the system respond? And what has the role of civil society been in those responses from the organization and or other states? Because what we see in the African system is that there tends to be silence when countries like Benin, Cote d'Ivoire, and Tanzania all withdrew recently. And it would be interesting to understand how the Inter-American system deals with these kinds of situations.
Thank you, Misha. Jennifer, are you able to make your contribution now? Jennifer?
Hello? Hello?
Oh, yes, we can hear you. Please go ahead.
Okay. My question will be how, because in Nigeria where I am, let's say the government find it so difficult to obey the rule of courts, and we've been like fighting for that to make sure that the rules of courts, like judgments, are being adhered to, and we're also having it so difficult here. I don't know how other countries on how the African courts can actually intervene in the situation, because it's been so bad for us over here with the lawyers. That's it.
Thank you, Jennifer. Before you wrap up, Florencia, I see one question or two in the chat box. The Indo-American system, through its human rights justice, is exciting and worthy of admiration. The follow-up section of the recommendations. It goes on to say, in 2018, a strategically coordinated and integral monitoring entity will be strategically established, or is it supposed to be strategically established? But could you tell us something about the downside of the upside of this system? Are you getting the sense, Florencia?
Yeah, but I think I mentioned a lot of downside, but yeah, I can. I can try to.
So yeah. All right. The second and final part says, do you think it is necessary for Africa that it is always necessary to rely on the Indo-American system to make reforms in the name of the principle that we should not reinvent the wheel, we should not re-engineer the wheel? I hope you also get the sense of that question. Should Africa, is it necessary to rely on the Indo-American system when we make reforms under the guise of the principle of saying we should not reinvent the wheel? I think with that question, that would mark the end of the list of questions that I have in the chat box, and also contributions made by participants. If you go through them, we'll be wrapping up with this session, and we are over our time, just about 20 minutes now. So I think we should wrap up. Please, Florencia, you want to react to the last comments and questions?
Yeah, sure. I will try to remember all of them. Please, if I forget some of them, you can remember.
Yeah.
So I will begin from the last one. I don't think there have to be, I mean, I know very, very few from the African system, but in terms of procedure, I don't think there has to be like something changed. I mean, at least what I have read about it, it's very progressive, and I mean, this direct access to the court is great. The thing is that the states do not like ratify that part of it. But I don't think, and I think that many of the changes that the Inter-American system were made to also provide with more access for the victims to the system, to the direct access, because at the very beginning, in the first years, the Commission had a more like active role in the whole procedure of individual complaints, and right now it's completely different. I think all this has been addressed at the African system, so at least that's my perspective. Maybe like Evelyn can provide more of her insight about that, but yeah, in terms of procedure, I don't think there's something you need to change. And also talking about compliance, I'm not sure how it works in the African system, but what you have is at least is more like it is established in the procedures how it's going to be the compliance. In the Inter-American system, we have to come out with these ideas. The court didn't have a compliance group until 2015. Until that time, there were the same. I mean, when I was there, I was the one that worked on the decisions and also on the compliance and also on the precautionary, on the provisional measures. I think right now, like having this group is better because they can see the whole picture of the compliance of a country and see more the structural problems that you can see on each of them. And I think in Africa you don't have that problem, but that's my idea of what I have read, and I don't know how it's in practice, right? So that about the procedures, and then the question about the downsides of the system. I'm not sure what else I can tell you about that, because I think I cover.
Hello.
Hello. Yes, Louis. Sorry, Florencia. The interpreter is
okay.
It's back to life. Louis.
Yes, I had lost the sound. I can hear you, but my voice is not heard. I was wondering whether they could try to reconnect me as an interpreter again.
Okay.
Yes, there was a power cut. When it came back on, somehow I can hear you clearly. Okay.
Mm-hmm. Yes, I can hear you. I can hear you. Yes, I can. Okay. Florencia, please proceed. Sorry for the interruption.
No problem. I was going to ask, I don't know who asked that question about the downside of the Inter-American system.
Mm-hmm.
If he or she was thinking about something specifically, I will be happy to answer. But yeah, I'm not sure what else I can tell you about that I haven't mentioned.
Mm-hmm.
And then the question about the reaction of the OEAS and the civil society to states withdrawal. There have been like public, the OEAS, I mean the state representations before the OEAS have released public statements about the Venezuela situation, for example, that haven't been an issue. I think it's because it's Venezuela, and I mean, most of the countries do not have like an issue to do it. I don't think it will be the same if, for example, Argentina do it. That's it. It really depends on the role of the state at the OEAS and how is the relation with the US. So that's basically how they reacted. In the case of civil society, the same. We also like came out with a public statement, and we try also to work on an investigation about how the impact of Venezuela withdrawing, because, well, since it's one of the worst human rights situation in our region, of course, we saw that we were leaving the people without any protection. So how was going like the commission and the court to proceed after the withdrawal? We also try to promote that investigation and that kind of answers from the commission and the court, this more at the like private and bilateral meetings. But yes, that has been the reaction, and yeah. And I don't know if I'm missing any other question.
No, I think you've just covered the questions that we had, and I've already mentioned that. Thank you, Florencia, and I'd already mentioned that we are closing the session now, but of course you are presenting with Evelyn, whom I think is still in attendance. Although no new questions were put to her in the general discussion. Evelyn, do you have any parting words from your end as we wrap up?
Thank you, Tarisai. Thank you to ACC, Florencia, co-presenter, and to all the participants for taking part. Thank you very much.
Thank you, Evelyn. That sounds like a vote of thanks. But thank you nevertheless. Thank you to our presenters, Evelyn and Florencia, for really opening our minds and tickling our minds in terms of the issues that we continue to confront here in Africa, but also in the Indo-American system. And as I mentioned at the beginning, it was a day also to see how these two systems work together and learning from each other, leaning on each other in terms of drawing inspiration from each other going forward. For those participants who were not able to make their contributions, unfortunately we've run out of time. We are trying to manage time in every module so that we respect people's schedules that they have after these sessions. We thank the African Code Coalition, of course, for putting this together, and the Raoul Olympic Institute, a close friend, to facilitate this webinar, the second webinar. There are two more webinars to go in the next 2 weeks. Let me just whet your appetite by telling the participants that the third one is on the 12th of October, and it's on inclusion of gender issues while engaging with the African Court and the African Commission on Human People's Rights. So the gender issues, they are going to be dealt with, elaborated on, and let's see what is the African outlook as far as gender issues and engagement with our human rights bodies is concerned. And then, of course, finally, on the 16th of October, if nothing changes, we will then deal with the implementation mechanisms at national and regional level, looking at effective tools to follow up on implementation of decisions of the court and recommendations of the commission. I think we've had a number of points on the practice of the Indo-American system as far as implementation of decisions of the court is concerned. But in the fourth webinar, on the fourth module, we really dedicate the whole more, presentations, both presentations, to dealing with the issue of implementation. But what is litigation if the decisions are not implemented? It does not make any logical sense. So it is important for us as participants at national level also to understand our roles, our opportunities, our windows of opportunities in terms of implementation of decisions of our human rights bodies. It is only implementation that can change the lives of our people after violations. I'm also reminded to remind participants that please take part in the survey There are some questions that have been posted on the website of the African Court Coalition. Please take a few moments to participate in that survey. It is through these surveys that we're able to evaluate ourselves, to evaluate what has happened, how we can make it better and more effective in the future. With these words, I want to thank everybody for participating. Again, to a special mention to our participants who once they log on, they remain logged on throughout the session. This is very impressive. Yeah, I really personally appreciate this, and the African Court Coalition, our conveners appreciate this, that once you are with us throughout the process. We really appreciate your participation, and we look forward to seeing you again on the 12th of October when we look at inclusion of gender issues in the engagement with the African Court and African Commission. Thank you and goodbye. See you next time. Bye-bye.